Hi, I'm Elise and I'm an attorney with the Commons Law Center, a nonprofit law firm based in Oregon. This video is for educational purposes only, and it is not legal advice. I am not your lawyer. If you have a legal problem in Oregon and are worried that asking a lawyer for help is going to be too expensive, please go to www.thecommonslawcenter.org to access our library of free legal guides and videos and to see if you qualify for our unbundled and reduced fee services. Custody refers to the legal right and responsibility to care for someone. If you have custody of a child, this means you are responsible for making the major decisions about that child's life. These include decisions about their housing, education, religion, and medical care, among other things. This video talks about how custody is decided, so if you want to learn more about what custody is, please watch our video, What is Custody? Until the court decides otherwise, both parents have joint custody, meaning they share the decision-making right and responsibility. If there is a court case about custody, the court can only order joint custody if both parents agree to it. If the parents can't agree to joint custody or on which parent should be the sole custodian, the court has to decide which parent gets sole custody. So how is custody decided? In Oregon, the court is required to make a decision about custody based on what is in the best interests of the child. When determining what is in the best interests of the child, the court has to consider at least 6 factors. Considering all of these factors, the court then makes a decision about who should be awarded custody. First, the court considers any emotional ties between the child and other family members. The court looks at if the child has strong relationships with grandparents, other siblings, aunts, uncles, cousins, and so on. If the child is closer to one of their parents' family members, this factor weighs in favor of awarding custody to that parent. Second, the court considers each parent's interest and attitudes toward the child. The court looks at how much time and involvement each parent has to give the child going forward and how they have acted towards the child in the past. A parent that has been more involved in the child's education, healthcare, and activities is more likely to have this factor weigh in their favor. Likewise, a parent that has demonstrated a negative attitude toward the child and has rarely been involved in their life will have this factor likely weigh against them. Third, the court considers whether the child's relationship with each parent should continue. The court wants healthy relationships to keep growing, so good parent-child relationships are encouraged. Unhealthy relationships between a parent and a child are also taken into account during this factor. Physical and emotional abuse are just some of the types of unhealthy relationships that the court might consider under this factor. Fourth, the court considers whether one parent has been physically abused by the other parent. This factor only applies when one parent has physically abused, physically threatened, or sexually abused the other parent. When one parent has abused the other, the court presumes that the abusive parent should not be awarded custody of the child. This presumption can be rebutted, meaning argued against, but it may be difficult to do. Fifth, the court looks at who has been the child's primary caregiver in the past. The court prefers to give custody to the primary caregiver if they are still able to act in that role. The primary caregiver is the parent that typically helps the child with morning and bedtime routines, meals, baths, plays with the child, takes them to school, to friends' houses, and doctor's appointments. If one parent has been more involved with the child's daily needs, the court will be more likely to award custody to that parent. However, that only is true if they are considered fit. A parent could be unfit if they cannot meet the child's needs, neglect the child, or abuse them. Finally, under the 6th and last factor, the court considers how effectively each parent will be able to encourage the child's relationship with the other parent. This might be hard for separated parents to think about if they have had a bad relationship with their ex, but Oregon law considers this an important priority. The court often considers each parent's past behavior regarding the child and the other parent, considering how each parent talks about the other parent in front of the child, how willing each parent has been to update the other parent about the child's education or health, and how much effort each parent has made to make sure the other parent has a relationship with the child. This is typically a very important factor in most cases, and where we see most clients often get into trouble. The 6 factors that we have discussed are what the court considers when determining sole custody. None of the 6 factors by themselves will be enough to make the decision. The court has to weigh all 6 and might also consider other relevant information. But there are some things that the court cannot consider. Things like a parent's disability or lifestyle are legally irrelevant to custody decisions as long as they don't cause risk to the child. Ultimately, the decision will come down to which parent will be able to best provide for their child's best interests. Thank you for watching. If you have questions about custody or how these factors apply to you, call us at 503-850-0811 or visit our website to learn more about the Commons Law Center. If you think you might need personal legal advice, please give us a call or check out our legal resource guide. It lists all the free and low-cost legal services that we know of in Oregon.